The 4 top ways to keep your home out of probate. This is estate planning lawyer Michael Pevney, and I create estate plans for California families. Now, the first way is a little bit of a trick, right? And first we should start and talk about what probate is in the first place. Probate is the government and state-controlled asset distribution program. Your estate, the stuff that you leave behind, the property that you leave behind when you pass away, if it's not inside of a trust or it's not titled in a certain way, would have to go through probate. Now, probate, where I practice in California, is a very costly endeavor, and it takes a long time. It can cost the average homeowner, or rather the people that they leave behind, about $50,000, which is a lot. And it pales in comparison to the cost of setting up an estate plan. And it can easily take 1.5 to 2 years or so to complete that entire process. So let's start with the 4 best ways to keep your home out of probate. First, you can sell it, right? And that one's a little bit of a trick, right? You can sell it and spend the money or put the money in a bank account or give the money to somebody. You can no longer live in the home, or maybe rent that home from the person that you sell it to, something like that. The second way is you can put somebody else on the deed to a home. When something is owned jointly by 2 or more people, typically this is a spouse. If it's jointly owned by a spouse and one of the spouses or one of the joint owners passes away, that home does not have to go through probate. But what it does mean is that it's not left through a will or through a trust. And what happens is the other person, the second owner, just ends up owning that property. It's called a joint tenancy with right of survivorship. Typically, if a married couple buys a home together, that's how it's held. It'll often say, in my situation, it will say Michael Pevney and Heather Pevney, husband and wife, as joint tenants with the right of survivorship. So that keeps it out of probate. But then what happens when the first spouse passes away and then the second spouse is left alone? When they pass away, if they have a will set up, things in a will actually do have to go through probate. That's a little bit of a common misconception. Or if there's no estate plan set up at all, no will, no trust, no nothing, when that second person, who now is the sole owner of that property, passes away, then yes, it would have to go through probate. And so that is something that we typically would want to avoid. We want to make sure that ownership is done in such a way so it won't have to go through probate when the second person passes away. The third way for a home to avoid probate is you can have what's called a transfer on death deed, meaning that you'd file a deed at the county clerk's office. If somebody owns the home on their own, they can have a beneficiary on that deed, meaning when they pass away, that house automatically passes to that beneficiary. They own that home. You present a death certificate and an affidavit and the deed, and now the beneficiary is now on that deed. And that can be a good way. Many states have this deed. California does recently have this deed, and that's a way to pass a home along to somebody or more than one person if they pass away, and you don't have to go through probate, which is a good thing. I'm not a huge fan of these deeds for a couple of reasons. First, there's no plan for incapacity. If the person is incapacitated who owns the home and they don't have the ability to sell the home if they need to, or they have some sort of health condition, or they just want to move, or the person that's their conservator thinks they should move, they're not able to do that. And there's no way for the beneficiary to do that on their behalf if they don't have some sort of estate plan in place. The second reason I don't like this third way of avoiding probate is that when the person dies, the beneficiary, that property is open to creditors, meaning if that person is going through possibly a bankruptcy or a lawsuit or a judgment or has a financially abusive spouse and that property comes into their hands, whether they like it or not, that can be open to judgments, meaning that that property could be open to creditors. Now, the fourth, and in my opinion, and many estate planning lawyers' opinions, the best way to own real estate and avoid probate is to place the property inside of a trust, a revocable living trust. And so you do a deed, you transfer the property into the trust while you're alive, with you as the trustee, meaning you have complete control over the property. You can take another loan out on it. You can sell it. You can add on to it. You can pretty much, it's the same as owning the property yourself as long as you're alive. And then what you do is the people that you want to inherit the home, you make them the beneficiaries of that trust for after you pass away. But if they are young, or they're maybe not the most responsible, or they are open to creditors, or they are not the most responsible people with money, once you pass away, the home is actually owned by the trust, and so it remains in the trust and has to follow the rules and terms of that trust on how it's to be distributed. And typically, a trust is almost always going to have a clause in there that's saying that we can't actually put the home that's in the trust into the name of the beneficiary if there's a judgment against them, or there's going to be a lien against that property, or there is in some way a danger of that property going to somebody else. And it also has the advantage of completely bypassing and completely avoiding probate. So like that example I was talking about earlier, where you have two spouses that own a home jointly. After the first spouse passes away, the second spouse will own the home, but then it's up to the second spouse to do something with that home. They need to put it in the trust, or they need to put a beneficiary on it. When a married couple sets up a living trust, they don't have to worry about that once the first spouse passes away, because the trust provides for that situation. So just to sum up real quick, the four best ways to keep a home out of probate, which we want to do. We do not want to do that because it's costly and it takes a long time, is first, you can sell the house and do what you want with the money. Second, you can own the home jointly with somebody else on the deed with a right of survivorship. Third, you can make a beneficiary, have a deed with a beneficiary so that the home goes automatically without probate to somebody else. And fourth, and in my opinion, the best way to do it is to place the home inside of a revocable living trust, meaning that once you or you and your spouse are both gone, the home passes smoothly without probate and safely to the person or persons that you want it to go to. If you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to my website, ocestateplanlawyer.com. Thanks for your time, and thanks for your attention.